We're also standing by with News 13's Christine Webb, who's covering our live chat. Don't forget to take part in that to get your questions answered. We have our legal analyst, NeJame, also on hand to answer any legal questions you might have. All right, right now let's go out to Kelly Cook. Hi, Kelly.
Hi there. How are you, Jackie? Yeah, we're done with recess. We have come back from the lunch break, and they went directly into a sidebar. A little unusual. Typically, they get right to it and call the next juror. So far, in this case, we have seen 27 potential jurors, and we've seen quite a different array just on today. The first juror was a retired gentleman who spends his days golfing. Another had just graduated high school, was a potential juror. As a matter of fact, he was a junior in high school at the time when this entire incident took place, and the day that when Trayvon Martin was shot back in February of 2012. And then there was that slightly controversial juror, E81, that everyone seems to be talking about. Very opinionated, very honest, exactly what they want to hear from potential jurors if they have any particular biases that they might be bringing into the courtroom, or whether or not they have too much exposure to the case. Well, E81 admitted that when she got her jury summons a few weeks before, she did start paying attention to that evidence and then trying to see what she knew about the case. And I tell you what, she certainly knew a lot, and admitted that she formed an opinion that she thought George Zimmerman was innocent in this case. All right. They have been taking about the same amount of time that was speculated by Mr. O'Mara. He was thinking it's going to take about 30 minutes or so for them to question each juror. He's absolutely right. We've been keeping a close eye on how long they have been interviewing each potential juror. And our producer here has come down up to about 35 minutes, 33.5 minutes at the start of the day. So defense attorney Mark O'Mara was absolutely right. It's going to take them about a half an hour to go through, on average, each potential juror. While they continue with the sidebar there, I want to bring in News 13 legal analyst Mark NeJame, who is standing by. Hey, Mark, you got a little shout out during one of the witness questioning earlier today. She did say that she watched you and watched some of your interviews. So I want to get your take on a particular bit of a heated exchange between the two attorneys. They just broke up the sidebar. Mark, we'll get to that in just a few minutes. Let's go back into the courtroom. All right, so I got to throw this out to our News 13 legal analyst, Mark NeJame. You're standing by. I know you just heard that. I, for one, Mark, never heard an objection to an objection. What do you think are your thoughts on what Donald West had to say?
Well, that's not an objection in the rules of evidence, but I think that expressed the defense's frustration. Typically, you give leeway to each other. You give leeway to each other in opening and closing statements and in jury selection. And I think this was simply an effort by the prosecution to stop the direction it was going with the juror. And the defense was frustrated, and there wasn't really a legal objection that could be founded, so he just kind of wanted to explain it to the court in the form of a talking objection. This judge is correct in her rulings in the past that talking objections, speaking objections are not permitted. If we've got a minute, though, I'd like to get into what's really been going on with juror E81. There's no chance she's going to be on the jury. But what you've been seeing going back and forth is that the defense would obviously like her. She seems to have a predisposition that it would be favorable to the defense. The prosecution obviously doesn't want her, and they would want to be able to try to establish through her testimony as she's giving it under questioning that she should be stricken for cause. Remember, each side only gets 10 challenges on preemptory. So cause challenges don't go against you. So what's happening here is that the state wants to establish cause and the defense doesn't want to. They're coming back to the court, so we'll come back to you later.
That's correct, Your Honor. We agree.
So, Mark, let me get your take on that. Just by saying I can put my opinions aside in this particular situation, even making a statement like, I essentially think the defendant here is innocent, which is pretty bold and blatant. Is that enough to say, well, she could potentially go on to round two?
And therein lies the argument. The prosecution is going to say just because she said it and she labeled it as such that she would be able to put her personal opinion aside and listen to all the facts and the evidence. Through their questioning, they want to establish that that's simply not possible, that she's formed a solid opinion and she's read enough about the case where that no matter what she says, it's embedded in her mind and she's not going to be able to be fair and impartial. The defense, on the other hand, is going to be claiming quite the other. They're going to simply say, look, she had an opinion from what she knew in the papers or saw on TV, Channel 13 she watches, woo-woo, and then she ends up coming back and saying, but I can put all that aside once I hear all the facts and the evidence. And therein lies arguments between both sides for the court to make a determination. Again, the state is posturing to get her stricken on a cause challenge so they don't have to use up one of their 10 preemptory challenges. And the defense wants to force the state to use it as a preemptory and not as a cause. Judge is back.